Today, we will explore the fascinating interplay of retributive and restorative justice within the penal law system of Bangladesh. We'll delve into how these theories manifest in both the formal legal framework and in traditional community-based practices. Let's first discuss retributive justice. The Bangladeshi legal system, largely influenced by the Penal Code of Bangladesh 1860, is predominantly retributive. But what does this mean? Punitive measures. Retributive justice is rooted in the idea that punishment should be proportionate to the crime. In Bangladesh, the Penal Code specifies punishment for various offenses. For instance, crimes such as theft, assault, and murder have clearly defined penalties, including fines, imprisonment, and in several cases, capital punishment. Deterrence. Another key objective of retributive justice is deterrence. By imposing strict penalties, the legal system aims to discourage others from committing similar offenses. Historically, public executions are used as a deterrent, though such practices are now rare. Retribution. Retributive justice also emphasizes the notion of retribution, the idea that offenders should pay for their crimes. Section 302 of the Penal Code of Bangladesh, for example, mandates the death penalty or life imprisonment for murder, reflecting the principles of eye for an eye. Now let's shift our focuses to restorative justice. Although the formal legal system in Bangladesh leans heavily towards retributive justice, there are significant elements of restorative justice, particularly in traditional and informal settings. Village courts and shallis. In many rural areas, traditional dispute resolution mechanisms like village courts and shallis play a vital role. These community-based forms emphasize reconciliations and compensation over punishment. They aims to restore harmony within the community, often involving the offender making amends directly to the victim. Compensation. The Code of Criminal Procedure 1898 provides a legal basis on restorative practice within the formal settings. Courts can order offenders to pay compensation to victims, particularly in case of theft, assault, and other personal offenses. This approach helps address the victim's losses and promotes healings. Probations and parole. Furthermore, the Probations of Offenders Ordinance 1960 allows for probations of offenders, especially first-time and juvenile offenders. This approach focuses on rehabilitation rather than punishment, providing an opportunity for offenders to reintegrate into society. In recent years, there has been a growing recognition of the benefit of victim offenders mediation. Pilot programs and NGOs initiatives are increasingly promoting restorative, restorative practices, particularly in juvenile justice, to foster reconciliation and rehabilitation. However, the implementation of restorative justice within the formal system, framework, or setting faces significant challenges. Overcrowded prisons, lengthy judicial process, and limited resources for restorative programs pose hurdles to creating a more balanced and human justice system.